Good afternoon. Welcome to EduSat Network. Friend, as you know, we are having discussion on medical care, but today we will have something special which is very important to know all of us, and that is legal aspect of medical practice. And for discussion on this very topic, we have in the studio Dr. Rajesh Sarswardhan. He is in Department of Hospital Administration in All India Institute of Medical Science. He is a medical doctor, and throughout life in education he has been gold medalist and medical doctor turn administrator now. So he has experience of both the clinical world and also administrative world. So he will tell us what kind of conflict a doctor face and what really need to be done. So I think his knowledge and experience will help us to understand the legality with the medical practitioner in a new perspective and a new way. So on your behalf, I welcome Dr. Harsvarsan for EduSat lecture on this very topic. Welcome, sir.
Thank you, Mr. Amrinder, for giving me this opportunity to reach out to the people who are connected to your network. Good afternoon to all of you. It's Dr. Harsvardhan this side. I'll be discussing about the legal aspect of medical practice, where you would be looking at the perspective of both the provider and the seeker of healthcare services through any SCU, that is healthcare organization. To begin with, let us begin with the word itself, the word law. What do you mean by the word law? A law is something either overtly or covertly, written or unwritten, which is there to facilitate the peaceful and mutual coexistence of people in a civilized society. I usually begin with this statement that you can always justify yourself before law, but not before in law. The preamble to the Constitution of the WHO says that the enjoyment of the highest attainable standard of the health is one of the fundamental rights of every human being, without distinction of race, religion, political belief, economic or social conditions. Here is how I propose to go. I will be discussing a little about the conduct. We will discuss the background. Then we will see the entire compass of the law. Then we will discuss about the evolution as to how did it evolve over the course of years. Then we will discuss about different types of and sources of law. That we will discuss or elaborate upon the meaning of law. Furthering upon the same, we will discuss the historical perspective, the basic rationale which gave way to the evolution of this structured legal system all over the globe. Then we will further deliberate upon the role of law and law in public health, role of law in general, and then law with respect to the public health. Thereafter, we will talk about the constitutional perspective vis-a-vis the legal aspect and medical practice. Then we will discuss different reliefs available in case of any injury or any damage. What all the legal remedies are available for both the provider or the seeker of the healthcare services through any healthcare organization. We will then discuss about the medical malpractice and medical negligence, and then the different aspects of law which are applicable in the state context. What is law? Law is a system of rules usually enforced through a set of institutions applied to govern a group. It serves as the foremost social mediator of relations between people. Law shapes politics, economics, and society. Now, the compass of law. It is being said, and very aptly said, that law covers you from worm to tomb. The moment a baby is born, a birth certificate is made in his or her name, and after his or her death, there is a death certificate. So law covers you all through your life right from worm to Tom. So that is the compass or the spectrum of law along which we all move. We'll now discuss the evolution of law, because we can conveniently begin with the past to come to this, the present age. When people started living in an organized society, there were a number of practices which keep on, or which were being transmitted across the generations in a defined area, consistently and continuously. So these established norms or cultural patterns or traditions or customs gave birth to most primitive type of law, and that is customary law. Customary law is the weakest type of law as on date, as it stands today in the legal world or the legal system. So what all is being practiced by a specific group of people in a defined geographical limit through successive generations consistently and continuously is known as customary practices, and they are the origin of the customary law. So that is the way law evolved. When time evolved or people evolved further, people started adjudicating among themselves at different level. To begin with, at the level of village, and gradually when the civilization evolved, there were cities and capitals and everything else, and there was a system of courts. So then people used to define the code of conduct in general and in particular with respect to a particular profession or what all. So that gave birth to written law and a system of legal adjudication or legal remedy through hierarchy of courts all across the globe. Obviously, it varied in time scale. Somewhere it started early and somewhere it started late. And when the concept of democracy came in, and when there were elected democratic government all across the globe post industrial revolution, people used to have the third type of law, and that is the statutory law. Second was through the courts. So we get three basic type of law. One is the customary law. Second is the whenever we don't have any written law or code on a particular issue, and when that issue comes up before the jury for adjudication, jury discusses the issue from all the perspectives, from all the possible angles, examines all the variables behind that issue, and comes to a conclusion. And this conclusion, that is decision, the given by any court of law by jury, becomes the judge-made law or the judicial law or the case laws. They are the second type of law. First was the customary, second is the judge-made law, judicial law, or the case law. Third is when a sovereign country, through its system of legislation, drafts specific acts, is known as statutory law. So in all we have got three types of law. The strongest being the statutory law, the statutes. Second being the case laws, the judicial laws, and third is the customary law. So this way we have discussed the sources, evolution, and the types of law. In any civilized society, in any democratic country of modern days, nowadays or today, the legal system has got two basic divisions which run in tandem. One is the criminal judicial system and the other is civil judicial system. So there are two basic types of legal systems. One is the criminal judicial system and second is civil judicial system. This criminal judicial system is based on the premise that whenever a wrong has been committed unto somebody by someone, it becomes the moral duty of the state to protect someone from that harm and to stop that someone harming somebody. So it is basically punitive in nature. There is some sort of punishment for the accused for having committed that crime which is prohibited by law in that particular country or as per the law of the land of that particular country. Where the second premise that gives way to civil judicial system is the welfare justice. First was the punitive justice, second is the welfare justice. In case of welfare justice, the entire thrust is not on punishing someone, rather restoring right of the victim. Say someone has grabbed land of somebody, so the proprietary right or restitution of that right comes under the civil judicial system. So there are two basic legal systems on the globe or in our country as well. They are the punitive justice and second is the welfare justice. In case of welfare justice, the emphasis is on restoration of the rights affected, whereas in case of punitive justice, it is about the stopping someone to commit that crime and giving some punishment as defined by the law of the land. The third basic premise of the entire legal system over the globe, all across the globe, is that is known as thou shalt not injure thy neighbor. Thou shalt not injure thy neighbor. Or it's also known as neighborhood principle or neighbor's principle, as told by Lord Atkins. What did it say? It says that whenever you are committing or doing something, you are supposed to take care of the people who are or environment surrounding you who can possibly be affected by that act of omission or commission. A person who are so closely in this principle, the word neighbor means persons who are so closely and directly affected by the act, their state act of omission or commission, that they ought to have or you ought to have them in mind while performing them. Liability for negligence is based on a general public sentiment of moral wrongdoing for which the offender must pay. I'll repeat the same. This neighborhood principle says very clearly and in unambiguous term that whenever we are doing any act of omission or commission, we are supposed to take care of our immediate environment, which can possibly be affected by my act. So, to the extent it allows us, or we can do what all we wish to, without affecting adversely the surrounding of the people who are closely associated with the same thing. It's also said that, in other words, that your freedom stops where the nose of others begin. In medical parlance, the same thing is being said by Hutchison in a different manner and it's known as primum non nocere, that first do no harm. Accountability in medical practice has existed since the birth of this noble profession. Earlier it was unwritten but more accepted, now it is more written but diluted and hence contested and disputed. Now, the legal perspective of health. What is the role of law? I mean, see, I am talking or I am discussing or I am deliberating upon a topic wherein there is merger of two specialities. One is the legal system and second the medical practice. So, we would be examining it from both the perspective. From the perspective of legal system, from the legal side or legal angle, then we will discuss it from the perspective of medical angle. What is the role of law in medicine? It can attempt to provide the creation and maintenance of conditions in which such measures may be promoted or maintained, or at least impediment to health may be removed. So law can ensure or create or maintain the conditions in which such measures be promoted or maintained, or at least impediment to health may be removed. The law can take care of institutions and personnel engaged in healthcare so that they function with the maximum efficiency. Say, law can prescribe as to who all can be qualified to work in a particular healthcare institution. That way, safeguarding the health of the public and safety of the people. It is eminently the function of the law to prescribe the principles upon which failure by a healthcare person to discharge his or her duty properly be visited with appropriate legal sanctions. Or in plain words, law empowers people to take recourse to legal remedy whenever there is some legal damage during the course of receipt or receiving or any treatment or their stay in a healthcare organization. A certain type of regulatory approach becomes necessary in relation to substances, preparation and techniques used in healthcare. In other words, law has to take care of, say for example, the drug industry as to how they maintain their quality and other subtle parameters to ensure the safety of the people at large. Or maybe law can prescribe measures which have to be taken, say for example blood bank, so that the health of the people can be safeguarded. Now, role of law in public health may be by it can further legislate on certain aspects like prohibiting conducts injurious to health, programs or services to promote or protect health. The government is running a number of national health programs like Pulse Polio program, regulation of the production of these resources for healthcare as told earlier regarding like under the aegis of Drug Control General of India, there is National Drugs and Cosmetics Act which covers the entire gamut of the pharmacy industry. Provisioning social financing of healthcare, some sort of comprehensive insurance scheme where government can ensure the health of the people who are below poverty line or who belong to a particular sector. Say for example, there is a scheme called ESI scheme, Employees State Insurance Scheme, which ensures the health of the people working in the industrial sector. Establishing surveillance over the quality of the healthcare. Government keeps on conducting a number of surveys, active and passive, so as to assess the status of the healthcare being provided either by the public or the private sector in the country, and use that information or the feedback as feed forward for next planning cycle to improve upon the healthcare delivery. And obviously we can't, it's being said and said aptly that where the law ends, ethics starts. So there are a number of ethical issues as well which ought to be taken care of, and this law chips in for the same. Now I'll come to the topic proper. There was a background that I built up. We'll discuss now the term is used in the legal parlance and medical parlance equally, that is professional accountability, that is duty to take care. Non-compliance of legal duty results in claim of legal remedy. Say, once a patient is enrolled in a hospital, it becomes legal duty of the concerned hospital or doctor to take care. So in that context, non-compliance of legal duty results in claim of legal remedy. So for example, a patient who has been admitted to a particular hospital and is not being given proper care within adequate time, and because of that he has suffered some damage or some injury or has bore some negative consequences of the same, he can sue the concerned hospital or doctor in the court of law. In view of the Supreme Court's judgment in the case of Parman Kataria versus Union of India 1989, it was clearly proclaimed that the ethical duty to treat on the part of doctor can be said to have acquired a legal character. We'll explain it right now. It was further decided that every injured citizen brought for treatment should instantaneously be given medical aid to preserve life, and thereafter procedural criminal law should be allowed to operate. Emphasis is on the timely medical intervention than only intervention. So the impact of the outcome of this decision was that prior to this judgment, the scene was entirely different. Whenever there was a RTA, the road traffic accident, and the patient was brought to a hospital, there were a number of legal formalities in case of government setup were to be taken care of before the actual treatment could be started. And in case of if the patient was rushed to a nearby a private hospital, they used to refuse and used to refer them to some government hospital because there was nothing, no legal precedent which was binding on the private hospitals to give at least first aid to the victim of an injury or accident. But the scene after the decision in the case of Parma Kataria versus Union of India is entirely different. Now it is, as well said, that the ethical duty to treat on the part of doctor has now acquired a legal character in the light of this judgment. Now no any doctor can deny giving first aid to a victim of any accident or emergency whenever the said patient has been brought to casualty, be it private or government, anywhere in the India. They just can't refuse. If there is evidence enough of refusal, the attendant of the patient or patient can sue the concerned hospital or doctor in the court of law. Or to say in other words, now it is the legal duty of every healthcare organization, set at whatever level, be it at primary level, secondary level or tertiary level, be it private or public or charitable, they cannot refuse rendering emergency medical care to a victim of accident or trauma whenever they are presented before such hospital or doctors. They have to render whatever, depending upon the facilities available or resources available at their disposal and the degree of or the level of the setup, they have to render whatever best they can before to save life before they can be sent to the higher institutions. And this article has drawn its authority from the Article 21, which is fundamental right of guaranteed by our Constitution. This decision has primarily culminated as a consequence of Article 21, that is a fundamental right under our Constitution that says or that preserves the, or guarantees the right of the citizen of India, their right to life. Their right to life. It preserves the right to life. So non-rendering or not giving medical aid in case of medical emergency to a patient by a healthcare provider would jeopardize his right to life as guaranteed under Constitution under Article 21. Thereby it becomes binding upon, subsequent to this judgment, the concerned healthcare organization to safeguard or to take adequate measures within the limits of their resources available and the constraints to give or render medical care before referring them to further or higher medical institutions. So it was a landmark judgment that has changed the landscape of emergency medical treatment being rendered in our country. Apart that, right to health has been upheld by Supreme Court to be the integral to the right to life guaranteed by Article 21 of the Constitution in the state of Punjab versus Mohinder Singh case. It was something like validating or upholding the same decision or further substantiating the same. Now the constitutional perspective. We will be now discussing or we will coming gradually to the alleged act of negligence in the context of medical practice. In the famous case Amelia Flounders versus Dr. C. Pereira in the court of Justice Bhagwati in Chagla, it was ruled out that actions for negligence cases in India are to be determined according to the principles of English common law. Further, Supreme Court in its momentous decision Paschim Banga Khet Mazdoor Samiti versus State of West Bengal held that the denial of emergency medical aid to the petitioner due to non-availability of the beds in a government hospital amounted to violation of the Article 21 of the Constitution. Now, as discussed earlier, with reference to the case of Amelia Flounders versus Dr. C. Pereira. It was told that we just discussed that in case of alleged medical negligence, the onus of or the adjudication would be based on the English common law. And English common law is set of judicial laws or case-based laws. The second important issue is the burden of proof. As in case of any other legal damage, here too the burden of proof lies with the complainant. So one who has complained of that alleged medical negligence has to prove that this act of omission or commission leading to some injury to the concerned patient has been done or was committed unto him or her. If he fails to prove that alleged act of negligence, the concerned healthcare provider, hospital, or doctor would be absolved on their own. They don't have to defend. But there is an exception, that is known as in legal parlance res ipsa loquitur. When the alleged act of negligence is so grave, so gross, so evident, so overt that it is common, it can be seen by anyone with a common sense that it is a case of negligence. So for example, if a doctor leaves a cotton swab or a scissor or an artery forceps inside the abdomen while operating upon the patient. So whenever the alleged act of negligence is so grave or so grossly overt, then the dictum or doctrine of res ipsa loquitur will be invoked, and in that case the onus of proof or the burden of proof lies with the defendant. In this case, the doctor or the hospital has to disprove that there was no act of omission or commission or any negligence on their part. If they fail to disprove, the alleged negligence would be considered to be proved. So we'll repeat again about the alleged medical negligence and how do courts arrive at a decision. There's a famous test known as Boehm's test. So in any case of alleged medical negligence, in any court of law, in our country or for that matter all over the globe, it has been established practice now that particular case under consideration would be adjudicated or may be seen in the light of the Boehm's test. Now what is Boehm's test? Boehm's test says that courts, while adjudicating any alleged case of negligence, would presume that or would adjudicate with this presumption that under the same set of circumstances, what all a reasonable doctor or hospital would have done with the same set of resources and same set of constraints, the same degree of skill set, experience, and the level of care. Say for example, if a baby is brought to a primary health center with continuous vomiting, the same case has been brought to a district hospital with complaint of continuous vomiting, and the same case of a baby vomiting continuously has been brought to a medical college. And say all these patients die. There is a death in all these three cases. At primary health center, the case was treated by a general medical officer or general doctor, a non-specialist doctor, whereas at a district hospital, the case was seen by a pediatrician, whereas in a medical college, the case was managed by expert of long-standing experience in the field of pediatrics, and with all the ancillary facilities available at that medical college being a tertiary care center. So, while adjudicating the issue about that alleged act of negligence, the court will presume that court will decide the matter presuming that what all steps another doctor with same degree of knowledge, skill, experience, same set of resources, same set of constraints at same level of care would have done, or what all steps of reasonable care that particular doctor would have taken. If it can be proved beyond reasonable doubt in the court of law that the said doctor at primary health center has taken all these steps, what all could have been taken by any other doctor with reasonable skill and reasonable care would have done, then that doctor would be absolved of this case of alleged medical negligence. So court doesn't expect that a doctor would always do the best. It says that what all could be expected by any other doctor in the same set of circumstance with same degree, same skill set, same level of care, same all the parameters have to be same. So there would be a match as to court would be matching in a presumptive setup as to what all could have been done by any other person with exactly this, all add to the best extent possible set of circumstances. That is what is the Bolam test, and it is accepted all across the globe in medical circle and legal circle both. So that is the in case of any alleged medical negligence, the first recourse available is to file a civil suit in a civil court, unless it is so gross that there was a death because of grossly evident act of negligence, then one can file a lodge a complaint or lodge an FIR, and then a trial can be instituted in a criminal court. So both these options are available for an alleged victim of an alleged act of medical negligence. Unless it is very grave and gross, it would not be trialed in a criminal court. It would be trialed in a civil court for some corrective measures, some recovery of damage or what all. Now there is another law known as law of tort, which is invoked in case of any alleged act of negligence by a healthcare organization, be it a doctor or hospital, to recover some monetary compensation, to have some monetary recovery, they want some monetary recovery or being paid for the loss they have suffered. Law of tort can be invoked when these three tenets can be met with. That if it can be proved in the court of law, in the civil court again, that there was a legal duty of the concerned doctor to take care of the concerned patient, that there was breach of duty, that doctor did not do what all he or she was supposed to do, so there was a breach of duty. Then there was a damage resulted, or the concerned patient suffered a damage, and that damage was direct consequence of that breach of legal duty. If all these can be proved in a court of law, the civil court or through the welfare justice system, then doctor can be sued and can be made to pay money in lieu of the damages suffered by the concerned patient. So law of tort is again a legal remedy available to the patients in case of alleged act of medical negligence, wherein a suit can be filed in a civil court for recovery of or for monetary compensation. For non-monetary actions, one can file a simple civil suit in a civil court, or in case of gross negligence, one can lodge a FIR for it, and then a trial can be instituted or started in the criminal court. Now there is a term called vicarious liability. Say a hospital has employed 5 doctors, and a particular doctor has committed an act of negligence or an alleged act of negligence by an act of omission or commission. Then it's not only the doctor who will be held responsible, rather this hospital can also be held responsible. because it is the duty of the hospital to make sure that doctors appointed or working in that part of the hospitals are of or are having the required knowledge, skill, degree and other things. Or maybe another example, say a patient who has been brought out of operation theatre has been shifted to ICU and could not be revived after a cardiac arrest for want of oxygen or because of non availability of oxygen. So in that case again, hospital can be sued vicariously. So in a case, court ruled that furthering this, a patient himself chooses the doctor and goes to him, the employer, the hospitals will not be responsible for the act of the doctor. However, if the patient approaches the hospital for treatment and by virtue of this consults a doctor employed, there is no reason why the hospital should not be held liable vicariously for the negligent act of the doctor employed by it. Government hospitals, or for that matter any healthcare organization, are vicariously liable for the negligent act of their employees. It has been made clear in the Indian law by the Supreme Court recently in the state of Haryana versus Santra in year 2000. Now, the penal provisions or the legal remedies available under the Indian Penal Code in our country. Section 304A is known to all of us. Culpable homicide not amounting to murder in case of very gross negligent act of omission or commission. There are three more. There is Section 336, 337 and 338. 336 says that the concerned accused can be penalized if the negligent act endangered the life without actual harm, whereas 37 says when the injury was there but there was no criminal intent, so the penalty or the penal provisions are lower in this case, and 38 says whenever there is a grievous hurt. Law clearly defines the grievous hurt. Say for when there is injury to the limbs or eyes, ears, all these are defined as grievous hurt. So in case legal remedies are available and the penal provisions are available under Indian Penal Code under the punitive system of justice, and there are defined safeguards available, and there are definite penal provisions for the alleged accused. We'll just deliberate upon before concluding what is medical malpractice. Failure of medical professional to meet the standard of good medical practice. A medical professional may be a doctor, a nurse, a medical technician or other healthcare worker. This is very important. It has been clearly established that a medical professional is not only a medical doctor who is rendering a direct medical care. Rather, nurses, medical technicians or paramedicals, they are equally covered or under the word medical professional, and they can equally be sued in the court of law for any alleged act of negligence. Concept of medical malpractice is very broad and it involves virtually every kind of mistake. Negligence has been defined as a careless state of mind or recklessness, breach of legal duty to take care which results in damage. Thus, negligence should prove three things: that there was a legal duty of care, that this duty was breached, and this breach resulted in damage. Thus, unexpected developments and complications and risks in medical care cannot be considered as negligence if these have been explained to the patient and or attendant beforehand. Medical negligence simply means a failure on the part of the doctor by not acting in accordance with established medical standards in vogue which are being practiced by a prudent doctor practicing in the same profession. These are the same thing. The first part I discussed was akin to the tenets of the law of torts, and the second part is somewhat what is prescribed or what has been accepted under the Boehm's test. To repeat, There's another term. Say a patient who underwent some treatment under the suggestion or advice by some doctor or some hospital has suffered some damage. But if the reason behind that actual damage was non-compliance on the patient's side, say he failed to take that particular medicine or he did not comply with the instruction given by the doctor, and that resulted in a damage, then he cannot sue the concerned practitioner or the hospital in the court of law, because he himself has contributed to the damage and is known as, in legal parlance, contributory negligence. So patient himself has contributed to his damage. There could be ratio, albeit there could be possibilities that there was a bit of negligence from, if it can be proved in the court of law that there was a bit of negligence from the provider's side as well, then patient can sue the concerned provider in the court of law, but then the legal remedy or monetary compensation will be much lower, as he or she has also contributed to the said damage or said act of negligence. So to sum up, in all, there are 5 types of legal remedies available before a patient in case of alleged medical negligence. First is, if the act of negligence is very gross, very evident, very overt, then he can lodge an FIR and a trial can be instituted in the criminal court. In case of negligence which is not that severe, not that gross, he can file a civil suit in civil court for some legal remedy or some compensation or some restrainment even. Third is, he can file a civil suit in the court of law for monetary compensation. Next is, he can lodge a complaint with the concerned hospital's administrative structure, wherein disciplinary action can be taken against the concerned employee for that alleged act of negligence. So these are the legal recourses available for any patient who has suffered any damage out of an alleged act of negligence by a healthcare provider. Now, there is another way, that is the 5th remedy, and that is available under the Consumer Code. The Consumer Protection Act 1986 empowers every consumer to sue the provider of a particular service or product in the court of law for the deficiency in the service or product rendered or provided. The law says it's the body of those rules and regulations which people have established to make easier to live with each other in peace and harmony. Under the Consumer Protection Act, a complaint is an allegation shall constitute a complaint where the services mentioned in the complaint suffer from deficiency in any regard. It applies equally to either product or service. If I purchase a toothpaste from market, or if I avail a service of a bank or hospital or an insurance sector, so it covers both the product and the service. Both can be both are treated, or both are under the ambit of the Consumer Protection Act. A complainant, who are the complainant under the Act? Any consumer or consumers, any voluntary consumer association if they are registered, or in case of death of consumer, their legal representative or higher. Consumer Protection Act clearly says that any person who avails of any service for consideration, if this service or product is availed free of cost, then consumer has no right to make a complaint or lodge a complaint in the consumer court for the alleged deficiency in that product or service. But if that product or service has been availed by giving some consideration or some money or some fee, something like that, then it confers the right on the concerned consumer to lodge a complaint in the consumer court for recovery or some legal remedy. So it says any person who avails of any services for consideration which has been paid or promised to be paid either fully or partly or in a form of deferred payment, but not in a case if person avails it for commercial purposes. So it applies to only the end users. Consideration means fees or payment to the doctor or hospital. It may be done by patient, guardian or any other person, or in case of death of patient, his legal heir is the consumer. And service. Service of any description which is made available to potential users but does not include the rendering of any service free of charge. Deficiency is any fault, imperfection, shortcoming or inadequacy in quality, nature and manner of performance of medical service rendered by the person or hospital. Now, what is medical negligence in this case under the Consumer Protection Act? If a service that has been rendered by a doctor or a hospital, if it falls short of reasonable medical care, the specific features or the what was the reason behind this enactment? I mean, what was the reason behind this enactment of this Consumer Protection Act? Because if someone lodges a complaint in civil court or in a criminal court, which are governed by the procedural law, namely Civil Procedure Code and Criminal Procedure Code, so it is a very lengthy exercise and the complainant has to pay some court fee as well. Whereas in case of consumer courts have been made free, so the Civil Procedure Code does not apply to the consumer courts. So that's why the dispensation of justice is very fast. So because the courts have not to follow the structured system of adjudication of justice as laid down in the Civil Procedure Code, so the justice is very speedier, very fast. That is the first advantage of lodging a complaint in consumer court for any alleged act of medical negligence instead of lodging in a civil court. Second, if a complaint is lodged in civil court, one has to pay court fees, whereas in case of consumer court, the court fees are not there. So it is available for free. So the legal remedy available through consumer court is both free and fast. That is the advantage. So it has revolutionized the entire concept of legal recovery for any legal damage, and it has empowered our consumers to a very large extent. The basic features or basic issues that governs the medical practice vis-a-vis the Consumer Protection Act can be concluded like this. Service rendered to a patient by a medical practitioner by way of consultation, treatment, medical or surgical would fall within the ambit of services, except where a doctor renders free services. The fact that medical practitioners belong to a profession and are regulated by the Medical Council of India does not exclude them from this Act. Services rendered free of charge by medical practitioners employed in or attached to national hospitals or hospital where such services are rendered free of charge to everybody would not be a service. Payment of token amount for registration purpose only will not alter the situation. Services provided at any non-government hospital where no charge is taken from any person and all patients are provided free service, they fall outside the purview of services and CPA can't be invoked for them. Services provided at non-government hospitals where charges are required to be paid by persons who can pay and persons who cannot pay are rendered free services would fall within these services, irrespective of the fact that free services is being given to only some patients. Recipient of free services in this case will also be a consumer. So even if single patient is being charged and rest of the entire lot of the patients are being rendered free service, even in that case that hospital would come under the ambit of the CPA. In case of any government hospital or health center or dispensary, if no charge whatsoever is taken from anyone and all are treated free, such service will fall outside the purview of CPA. if some charge is taken from some patients who can pay and others are provided free, it will still fall under CPA. Service rendered by a medical practitioner cannot be regarded as free of charge if the person availing has insurance policy for medical care. Hospital can't say that patient has not paid, and in that case too it will come under the CPA. And last, whereas the part of the conditions of service, the employer bears the expenses like CGHS for medical treatment of the concerned employee. Even in this case, the service would fall under the CPA. I believe the time is running fast now, and we ought to conclude. So, before wishing you a very happy new year in advance, I would like to repeat 5 major legal remedies available to any person who has suffered any damage from any healthcare organization. For legal remedy, they are: first, under the criminal system of justice, he can lodge a complaint when the alleged act of negligence is so gross or reckless where the doctrine of res ipsa loquitur can be invoked, or he can lodge a complaint in the civil court, he can lodge a civil suit for restrainment, or he can lodge a complaint in civil court again under law of tort for monetary recovery, or he can lodge a complaint in a consumer court for legal aid or legal compensation. And fifth, or the last, he can complain against the concerned employee of a particular organization, wherein the disciplinary action can be taken against the concerned employee as per the established rules of that particular organization in that particular country. Thank you very much. If there are any questions, you are welcome.
So these are very important to know, but from the point of view the general publics, so as you said that under CPC they can lodge the complaint, but what is the valid ground of how can a patient, the victim, have the evidence, because it is in the hand of the doctor who can anyway erase the evidence or destroy the evidence.
Okay.
So in that case, what is the, what left with the victims?
See, medical science is not an exact science. It's not a pure science where 2 and 2 always makes 4. But then still there is a system established, because we are a profession, we are professional. There is a system established and practiced all over the globe, wherein what all we do, we document. Once the patient is registered with a healthcare organization or with a doctor, he is given a token, a number, and then thereafter what all is being done unto the patient, for treatment or what all, it is being documented, and they are known as medical records. And medical records available with the patient can become a good evidence against an alleged act of medical negligence. I have been a member of the number of medical boards and the cases referred by National Consumer Disputes Redressal Forum, wherein patients have provided the copies of the medical records available with them, and which helped us to inquire and come to a conclusion before giving expert opinion as regards any alleged act of negligence.
What about in the case of conflict of diagnosis? Sometimes what the patient goes to one doctor and they do diagnosis on their...
A very apt question, and very apt question. See, there is an established term known as Boehm's test, and it has been accepted worldwide equally in the legal fraternity and the medical fraternity. Say, in a particular case of pain abdomen, one doctor says it is acute appendicitis and second says it is cystitis, say for example. So court would go, if the patient lodges a complaint as subsequent to any harm, court would go by the Boehm test, wherein court would adjudicate that what decision, what all steps and any other reasonable doctor would have taken in the same set of circumstances with the same case mix. If it can be proved in the court of law that the particular doctor took the stand which can be taken by, or should have been taken by, any other doctor of same degree of skill and level of expertise experience, and that is well documented and supported by the established medical literature, then one can rest assured that the diagnosis made by either of the doctors were right, because there are conditions wherein there could be possibility of more than one diagnosis, and both of them can be established by the medical facts and figures and precedents available.
Okay. In the major hospitals, what is the general practice is? Generally, people go for the treatment by a eminent doctor, the you say expert or the experienced doctor. But what happens is just contrary to that. The junior doctor do all the things, and they just, if the necessary be, they take the opinion of the senior doctor, and then they
Correct.
treat it.
This
Then-
is a very common myth. I will say it a myth, which is prevalent in the psyche or people or the community or public, that I went to consult a particular senior doctor and I was being taken care of by someone junior to him. Any hospital, especially a government hospital, has got a system of recruiting people which has got a rigorous, well-defined rules. Even a junior doctor is being given the responsibility to treat patients, but then there is a limit to which he can take a decision. Thereafter, he has to have the opinion of the concerned senior. Second, there is a legal provision of legal remedy under the a term called vicarious responsibility, wherein even if the care given by a junior doctor has resulted into some damage, the concerned patient or his attendant can sue the senior doctor only, because vicariously it is the senior one under whose guidance someone is working is responsible, not the junior person who actually delivered the care.
Okay, the last question I would like to ask you, because that is very easy escape, that we were doing all the things what the doctor say, but in the meantime the infection and other things came into, and that's why the patient or the victim could not survive. So is this correct to say, or
See, I said in the beginning that medicine is not an exact science. We can never proclaim the same medicine can work wonder for a patient, and the same medicine when given to another patient with the same disease can cause severe reaction and patient can die even. And it is well documented and well established scientific and medical fact. So medicine is not an exact science, first thing. Second thing, if ever something like this happens, court would again go by that Bolam test, that in the same set of circumstances, with same set of resource, with same set of constraints, with doctors with same degrees, skill set and experience, if somebody else would have been in the same place, what all he would have done? If it can be proved beyond reasonable doubt in the court of law that any other doctor in the same circumstances would have done the same, then he would not be said to be negligent in this regard.
okay? So well, friends, Dr. Harshvardhan dwell upon the various issues related with the doctors and patient legality, and he also talked about what are the options with you if you feel that you are a victim, you have been knowingly done by the wrong done by the doctors, and also talked about the what are the preventive measures we taken while going to this all legality, and what are the what is handy for your evidence when you produce in the courts. And but from the discussion we can conclude that after all the law is in your favors if you feel that you are victim or you have knowingly been done victim, so the law will protect you, and there is you must be beneficial of this. Don't forget
Before law, it is we always say that there is equality before law and equal protection of law available to each and every citizen, guaranteed by constitution of the country itself.
So, as Doctor said, we will conclude this word, and I thank all of you for watching the lecture. And on your behalf, I also thank Dr. Harshvardhan for giving such an insightful lecture on this very topic. Thank you very much.
Thank you all very much. Thank you.